the CLE committee's program, attorney grievances, how to avoid them, and what happens if you receive one. This idea was actually the brainchild of the chair from last year, Carmelo Morabito. He had planned this, and I think we were supposed to do it right around when COVID shut everything down. So we postponed it a year, but we were lucky enough to still have the same program and the same speakers who I'm going to introduce. We have Steve Cornelius, and Steve is a partner at Eccleston and Wolf, where he spent his entire career, starting as a law clerk in 2009. His litigation practice focuses on the defense of lawyers, healthcare professionals, and employment matters. He's previously presented on risk management issues and the pitfalls associated with litigating claims and Medicare liens. So thank you, Steve, for being here. We also have Erin Risch, and Erin joined the Office of Bar Counsel in April of 2018 as Deputy Bar Counsel. She was previously a principal at Eccleston and Wolf, where she concentrated her practice on the defense of professionals. She lectures throughout the state on legal ethics and risk management. So I know we are going to learn a lot from the two of them, and they are very, very well versed in this. I'm going to turn it over to Erin and Steve. And I guess we do have we have the ability to chat, so I'll keep an eye on the chats if anybody has any questions. And then we can ask the presenters on those. Okay. Erin, Steve, you good to go?
Thank you.
Okay, take it away.
Hi, everybody. Good afternoon. Thanks for joining us. Steve and I have put together what we hope will be informative and helpful presentation with some sort of statistical information, discussion of the rules, and with that, some do's and don'ts. And then Steve will close it out with some recommendations in responding to Bar Counsel and some of the new rules that are coming down the pike, hopefully. So we have a PowerPoint, which I did one practice of sharing this and it worked. So I'm sure this time it will not, but let me get this uploaded and see if I can do this correctly. Let's see. Can anybody see anything? No.
Your background's
a blue screen.
Your desktop.
There now.
Yeah,
No?
we see your desktop.
Perfect. That's what you're supposed to say. How about now?
Yep.
Great. So let's get to the first slide. And obviously, as Laurie said, if people have questions as we go, feel free to jump in through the chat, and hopefully Laurie will catch them and let us know. But I put together, these are some statistics from our annual report in the Office of Bar Counsel, the fiscal year 2020 statistics with what number of complaints we received and some other things about the cases that moved through our office. What you'll see is we were up in the number of attorneys again with 41,177 attorneys licensed to practice in Maryland. We saw less complaints this year, not by many, but a few less, 1,599. And of those complaints that were filed, 285 were docketed for investigation, which means that all of those other complaints were disposed of at the initial screening stage. And I think that's a really important number that I always want to point out to everybody, because I think what that really demonstrates is how, and Steve will certainly touch on this later, how many complaints can be disposed of at that early screening stage, and how few actually get to the docketed stage. So that's a really important time to take the time to formulate a thorough and good response, so that hopefully the matter doesn't go forward. Of those 285 docketed complaints, we had 28 disbarments, 16 suspensions, 32 reprimands, and 17 conditional diversion agreements. And all of those numbers were pretty consistent with, the past 3 to 5 years. So nothing substantially new there. The practice areas, which again, this is pretty consistent, that tend to get the most complaints, is civil litigation, family law, and immigration law. And one thing that I've noticed with a lot of the immigration cases seem to focus on sort of the competency and diligence issues, because I think there are areas of immigration law that are particularly specialized and particularly with the deadlines that come along with that, there can be some serious consequences when there are lack of diligence or competence. And then family law, I'm sure, will come as no surprise, along with civil litigation. Those have traditionally been two areas where we see a lot of complaints. Just then touching on, I want to talk about some of the most common rule violations that we see. Year after year, it is the rules relating to competence, diligence, and on the next slide, you'll see communication that tend to result in discipline, or the number of complaints that move to the docketed stage involve these types of issues. With respect to competence, I always like to point out that, you can be competent to handle a matter, but just because you're competent to handle a matter doesn't necessarily mean that then you competently handle that case. So I think that's something important to remember in terms of, whether or not you've been practicing in a particular area of the law for years and years and years, where you are certainly competent to be in that practice area or handling those cases. There's also a second piece of it, which really relates to the particular client and the particular representation. And in my opinion, diligence, and then this next rule, which we see many very common rule violation, communication. And I sort of break this down, and I know Steve will discuss this in the tips, in terms of communicating with the client about the status of their case is sort of one piece of this rule that is important, but also the obligation to communicate with the client so that they can make informed decisions about the representation is its own category, I think, of communication. And what we see a lot of is obviously the situation where an attorney falls down a little bit in keeping up with the communication. And we all know that clients can be demanding and difficult, and we've all had those clients. And you'll see in our tips that we give a couple recommendations, but you have the falling down on the day-to-day or week-to-week, month-to-month, keeping a client apprised about the status of the matter and responding to their reasonable request for information. That's a key word. But also then giving the client the information that they need to make informed decisions about the representation. And also, what goes with that you'll see in our tips is how you convey that information is the second piece of it that can really, I think, protect you as the lawyer if you are diligent in how you communicate this important information to the client. And so for our tips here, I'll let Steve dive in on some of these.
Sure, thanks, Erin. So keep in mind too that a handful of the tips that we'll go through are really from a best practices standpoint, ways to try to insulate yourself from potential problems, whether it's bar complaint issues or legal malpractice claims, or really just having a disgruntled client that you're trying to keep in check from progressing into something more than it needs to be. So on the kind of the areas that Erin just talked about, some of the initial tips is obviously screening difficult clients. Obviously people that are doing work, you have cases that you need to take, but oftentimes you can tell from the way people conduct themselves early on, are they or are they not going to be difficult to deal with? And screening those people is not just from a standpoint of do I or do I not undertake the representation, but it's also having a healthy mindset of how do I deal with this person going forward? Because if you have somebody that you highly suspect is going to be a problem, or maybe looking to point the finger at you down the road, you may be more cautious in taking phone notes, keeping your file up to date, documenting issues with them, communicating in writing, things like that, that while we should be doing in all of our cases, certainly when you have a heightened antenna with those types of clients, you want to undertake more of those issues. As Erin touched on, screening cases that go beyond your practice area, whereas you may be an intelligent human being and competent, sometimes venturing out or dabbling can be one of the worst mistakes you can make. One of the areas that we see come up in legal malpractice claims, for example, are, you are an employment lawyer and your website only talks about, I do employment law. But then, you take a medical malpractice case and something goes wrong. You don't file the right certificate, you don't comply with the deadline, the case gets dismissed. One of the exhibits we will see in that case is your website that shows these are the areas that you yourself hold yourself out to be competent in. On the communication front, returning phone calls regularly and communicating about the status of the client's case on a regular basis. One of the biggest issues we see are, disgruntled clients where it starts out with, they wanted a phone call, they wanted to be kept apprised as to what's going on, and they don't get that. It's similar with the research we see with doctors that get sued for medical malpractice, where, if they have a good bedside manner and they are addressing their patients with the right tact and approach and giving them the time and attention, the chances of a malpractice claim are significantly reduced. In the legal malpractice front, we look at that from are you communicating with your client? Are you involving them in decisions so that they can make the most informed decision based on actual issues that are taking place in real time? You want to move on, Erin?
Sure. I think one of the things that Steve touched on that I just wanted to sort of piggyback on is in terms of, I think on the defense side and the side of being in the Office of Bar Counsel, one of the things that it's true, you hear time and time again when there's a situation where there's a legal malpractice claim, a bar counsel complaint, very often you will hear if the attorney say, I knew I shouldn't have taken this case. I knew this person was going to be a problem. I had a feeling about this situation. And so with regard to that, really, go with your gut. If you've been practicing just for a little while or for years and years and years, most likely you kind of can get a sense at the outset of whether this is probably not a good road to go down. And so trust that instinct. The other thing I will say that we do see, and this comes in later with some of the other rule violations as well, is the sort of snowball effect of burying your head when you have an aggressive client, a needy client who is constantly calling you or constantly sending you emails at all hours of the night and expecting a response. The rule, as we looked at it, said reasonable request from information from the client. So if you're in a situation where a client is calling incessantly or emailing incessantly and getting frustrated that there's no response, if you bury your head, that's going to snowball out of control most likely, as opposed to early on setting the client's expectations, which is the first pinpoint here on this slide, and then be consistent with that. I've seen some attorneys come up with very strict policies where they will say at the outset, if you call my office, you will receive a phone call within 48 hours, a reply call within 48 hours, but you have to wait that amount of time, or, it's not going to be within 24 hours. And I think for some people that may work. And for others, that may be sort of an unrealistic, specific time frame to set. But if you run into a situation where you do have that client, and you get out in front of it early and say, this is not, I cannot respond to request in this amount of time. And I understand that you're dissatisfied, but here is what my, policy is, or something to that effect. And again, it just comes back to the communication and making sure that you're effectively communicating with the client. Sorry, Steve, I know you had something else to add there.
Yep, no, that's exactly right. And expectations being set early on can apply in so many different ways, not just on, what they could hope to recover or how a process is going to unfold, but certainly your availability and, certainly keeping them apprised of your status, putting up out of office messages, letting them know when you will get back to them. Things like that really seem to temper potential issues that have the opportunity to spiral out of control. Another tips on practicing in this area are sending letters of non-employment. So making it clear to people in writing that you are not that person's lawyer. trying to nip that in the bud of avoiding the issue of reasonableness, was there consent, looking at the intent of the parties and whether or not an attorney-client relationship is formed, the best way and most effective way to address that is to confirm it in writing that it does not exist. Just as we'll talk about later on, the importance of having retainer agreements, you want to make sure you are identifying early on, not just for conflict purposes, but also to avoid potential expectations from another person that may be looking at the same situation or sharing information with you in a different lens. That, are you their attorney? And having a very clear letter setting forth that you are not representing them. There's lots of good templates online that I would recommend using for that. Is a very effective way to avoid a potential blurred area coming up down the road.
I also think I was thinking of it today. I know of at least, I think, 2 cases, current cases in our office where it was the non-employment letter would have been so huge because they were both circumstances. It's not where somebody comes in and meets with you and then you tell them, I'll get back to you, or I'm not going to take your case, and you don't send the letter in writing. That's not what's going to get to the level of, most likely creating a problem. In the cases that I think it really happens is, and the examples I can give are instances where a client comes in and has a couple of things that they want to talk to you about, especially if you have a general practice, and they say, well, one, I feel, I want to bring, I think my employer is, I might have a claim against my employer, but also I have this traffic ticket that I want to deal with. And then, by the way, I also want to sue my neighbor because he put up this fence I don't like. And what the attorney was trying to do was deal with the cases, that needed time, that were time sensitive. And at the same time, didn't feel that some of the claims that the client wanted to pursue really had a lot of value. So sort of just pushed it to the side, and said, yeah, we'll look into that once we get through all of this. And of course, 2 years go by, and then you get the client writing back and saying, and by the way, what's going on with my claim against my neighbor? Have you sued them yet? And the attorney, it's not unrealistic that the attorney says, we haven't talked about that case in 2.5 years, 2 years, whatever the case may be. But what would really help is that, if there had been a clear communication saying, this is what I'm agreeing to take and handle, and this is what I'm not, and we can revisit this later, but I'm not representing you on this issue now. It would just make this attorney's life much, much easier. Now for some of the don'ts.
Right. So some of the issues we see where, you're trying to identify the problematic client out of the gate. Certainly, if you are the third or more lawyer that's being approached on a given matter, a red flag should be going up into your head. Certainly when you're the second person, something could happen in the first relationship, or an issue in that case. It could be mundane, it could be a non-issue that the person just has a finicky personality about. But usually when you see, third or more, that's when, you start raising an eyebrow, because there might be a reason why this person's having difficulty keeping counsel representing them on whatever their claim may be. And certainly if that claim involves, complaints about their prior lawyer or a legal malpractice claim, you better really think twice before you take that claim, because the odds are, if things don't go exactly as planned, then you will be in the crosshairs later on with somebody that has demonstrated a pattern and practice of being litigious and, generally disgruntled in that respect. In that respect, we go back to, the old adage of, with your sixth sense, if it says that you shouldn't do it, follow your gut on that. There's usually a reason why you have that impression when you first meet with somebody. And, if you're looking at the case and evaluating not just the merits, but also looking at, what's going to ultimately happen when I have to put this person on the stand and, worse yet, deal with this person for the next year, 2 years, 3 years in, high intensity litigation. You want to think about that before you make that investment of your time and resources representing that person, because, if your heart's telling you, this really isn't the path I want to go down, it's just like a multiple choice test. You should follow your gut on that and go with your first instinct.
Right. Well, now we covered the most common rule violations: competence, diligence, and communication. Second most common rule violations, I'm sure will come as no surprise. It's the rules pertaining to fees and to safekeeping property, which oftentimes work together or against one another. And so that's 1.5, which is the rule that prohibits an attorney from making an agreement for charging or collecting an unreasonable fee or an unreasonable amount for expenses. And 1.15, the safekeeping property rule, which requires that the attorney hold funds of clients or third persons in connection with the representation separate from the attorney's property. So this is the rule. I didn't put in all the subsections, but obviously that requires an attorney to hold unearned fees in trust and only transfer those fees into an operating account once they are earned. And along with that those fees, once they're earned, need to be promptly moved into an operating account or withdrawn from trust so as to avoid commingling. Also, the rules pertaining to attorney record keeping, trust account record keeping, you find not under the rules of professional conduct, but they're in the 419-400 series of rules. And that's where all the requirements are as to what records you need to be keeping or maintaining of disbursements and deposits into your trust account. But that group of rules is incorporated through Rule 1.15, and so that they are work together as well. I think when you look at fees and looking at safekeeping property, the most common things that we tend to see obviously are a client, an attorney charging an unreasonable fee for representation, whether that be not really so much that you see, a 75% contingency fee or something like that. It's more the complaints that we see in our office are your average, I paid X and the attorney, didn't earn that entire fee, or overcharged me, overbilled me for certain services, or they took my money and then they didn't do anything that they promised to do. So obviously ways to protect yourself there is, and Steve's going to get into this, is to set out the details with respect to fees in a retainer agreement. That's the first way to address that issue. And then with respect to the safekeeping property rules, a lot of times we see the misunderstanding by attorneys that flat fees can be automatically deposited into operating, and that, or language such as earned upon receipt, which is not permitted. So the idea being that if you enter into an agreement for a flat fee for a representation, that fee still has to be placed in operating and until it is earned. And what you can do set out in a retainer agreement is you can have what are typically referred to as milestones throughout the representation that would allow you to take a portion of the flat fee. So that's kind of what we see most, I would say, in terms of looking at 1.5 violations or 1.15 violations. And Steve's going to give some really practical tips on how to avoid a lot of these issues.
Sure. And so the first is obviously, that's more of a disclaimer just to comply with the rule of be reasonable when you're talking about your fees. But, in line with that too, certainly on the defense side of things, when we're looking at, a fairly small case, let's say a district court case, and you're charging your standard hourly rate, when you bill a client more than the jurisdictional maximum, that tends to raise an eyebrow. And that's usually something that's not practical and pragmatic in trying to balance, giving the correct representation and doing a good job for your client versus at the same time, managing the exposure and being practical in how you go about prosecuting that claim. Some of the tips to address some of the fee components, as you'll see on here, first is the use of an evergreen retainer, which is a tool that I regularly use in my practice, and I know our firm uses with respect to private engagements, where essentially an evergreen retainer has two components, where you request that the client put forth a retainer in a certain minimum balance to start with. And as your fee is earned and that retainer is depleted, you set then, the second part is an amount by which it would need to be replenished by a fixed amount. For example, what I might do is tell a client, hey, look, this case is going to involve a lot of time. There's a lot of issues in this case, a lot of discovery involved. So we request, a $50,000 retainer up front, where once that balance gets down to, let's say, $10,000, the client agrees to bring that amount back up to the full $50,000. Now, that sounds like a lot on the front end for a client to have to digest, but at the same time, that helps you as the attorney flush out a few issues and avoid some problems that should be pretty clear. The first one is what happens when you earn the fee and you're looking to get paid? You don't have to go tracking someone down. The money's already sitting there, and it's a matter of transferring it to the correct account. The second one is that if you reasonably expect that you are going to spend a certain amount of time and incur a certain amount of attorney's fees and expenses, and the client's telling you right out of the gate, I can't afford that. I'm not going to be able to pay that. That's something that identifying early on, the sooner the better, so that you aren't finding yourself with an accounts receivable balance of unpaid bills for 6 months, and then you're kind of between a rock and a hard place with where you are in the representation and trying to get paid at the same time. In line with those billing practices, certainly regularly billing is a key mechanism for not just avoiding surprises to your clients, but it also reinforces and facilitates that communication aspect of the representation. Not only are you telling your client, here's what we're doing, here's where we are, here's where I see things going, but now they're also seeing the bills, which allows you to keep them informed of, this is what I've done, here's where we're at as far as the time and expense is concerned, and there's no surprises on their end. They're fully informed as to what you're doing, and you should be communicating with them so that they know that why you are doing it. This also allows both you and the client to stay current on the status of unpaid bills and making sure that you're staying on top of following up with them. As we said before with the evergreen, identifying sooner the better a potential problem of a client that is not paying their bills. If you can address that early on, you may have to get out of the representation. And the sooner you can figure that out and do it, the better off it will be for both you and for the client as well. Going back to Aaron's point, while a written retainer agreement isn't exactly required, it would be for a contingency fee arrangement. We recommend having the scope of your representation memorialized in a retainer agreement in every case. I will tell you from a legal malpractice perspective, the retainer agreement is always exhibit 1. So the better and more clear that agreement is, specifying not just the scope of the representation, but also all of the billing issues, who's responsible for what, specifying what those costs may be, identifying those milestones that Aaron touched on, all of that being in writing, signed by the client and the attorney. The more clear and comprehensive that is, the better. That will help you both from a practice standpoint and from mitigating exposure down the road standpoint. And it'll also allow you to make sure that as you're going through the representation with your client, that you are performing and complying with the terms of that agreement, so that there should be no room for complaint from the client, whether as a surprise standpoint or from, I told you to undertake this additional task. It's like, well, that's not what I was retained to do. As set forth in the retainer agreement, this is the scope of my representation. I am handling this personal injury matter. I am not handling, this will dispute with your family members. I can't stress enough how important it is to have a very well drafted written retainer agreement, not only for in real time during the representation, but also when, if you find yourself in the unfortunate situation of, being on the other end of a legal malpractice claim, being able to rely upon that and have that as a defense tool as opposed to a weapon being used against you.
Steve is way too optimistic. There's always room for complaint, as most of us have experienced, no matter how diligent you are in trying to run through everything. But one of the things that I think is important to remember, I always get the question and I agree with Steve about, putting as much information in the retainer agreement so that, it's clear to the client what you're doing and what you're not doing, what your billing practices are, what your communication, will be like in terms of returning phone calls or something like that. And sort of, I think the companion question to that concept is always, well, come on, how, what then the next thing it'll be is that the retainer agreement is too long, because now I've got a 12-page retainer agreement where I've gone through everything under the sun that could possibly come up. And then I'll be told that that's, how could anybody possibly understand a 12-page retainer agreement? And so, and I appreciate and understand, obviously, the rub there. And I think the idea is that, looking at what we've just looked at in terms of most common rule violations and things that tend to come up a lot, I think those are the things to focus on if you're going to go through and include some of that information in your retainer agreement. And to be clear that you are, to look at it from a reasonableness perspective, obviously, and put it in simple terms that can easily be explained to any client, whether they're, they're more sophisticated or less sophisticated. And then some of the don'ts, Steve will let you know.
So usually this is where, I receive some pushback because, obviously telling people don't sue for your fees is somewhat of an idealistic view. But like I said, these are best practices to avoid and mitigate potential exposure. And the reason why we include, avoiding having to file suit to recover your fees is because, as some or all of you probably know, oftentimes when you do that, it will be reciprocated with a legal malpractice claim. So if you are filing a lawsuit to recover fees that were not paid, you can, almost be certain that in the majority of situations, you will be receiving at least a counterclaim for legal malpractice or the equivalent thereof. What's interesting about that dynamic is that, while you yourself or through, personal or private counsel may be bringing that suit to recover your fees, if you were to receive a counterclaim, oftentimes your professional liability insurance coverage kicks in, and then you have a whole team of lawyers at your disposal, so that you have the prosecution of your own fee suit, but at the same time you would have defense counsel to defend against the counterclaim. But as you can imagine, hearing the number of attorneys involved, the best practice is to do what you can to avoid that situation altogether. And the same rationale applies to exercising a retaining or what we call an attorney lien. Holding a client file hostage or asserting that lien against a settlement, whether or not you are discharged as the attorney or you're simply you've withdrawn because you have these unpaid bills. Keep in mind that the same rationale applies, that in asserting that position, it very well may welcome adverse reactions from your client. I can tell you that I have a case right now where it's a fairly small case of damages with questionable merits, so it would be a compromise settlement we'd be looking at. But the first attorney representing this individual, who is no longer in the case, has asserted an attorney's lien and sent it to, all counsel, current counsel, in accordance with the statute and the Maryland rule. And, that number has now set a floor that's going to prevent the parties from having meaningful, settlement discussions. So, if this case were to play out as I'm hoping it will, and this individual will not recover in the case, she very well may turn around and say, well, I was impeded in my ability to do so because of my original counsel's role in preventing me from being able to pursue that avenue. And in connection with both of those issues, the third position is kind of a catch-all with, identify these issues early, be in constant communication with your clients, try to identify problem clients and problem situations, because the sooner you do that, the sooner you can put yourself in a position to address those issues and hopefully not have to resort to what I would call the last resort of having to file suit for your fees or take a riskier position that could expose you to potential liability or at least a claim down the road that you would hope to avoid.
And so this is what I was referring to a little while ago when we were talking about Rule 1.15 and safekeeping property, and that it incorporates in it the attorney's obligation to comply with 19407 through 19410, which are the trust account record keeping rules. And if it's been a while, or never, but if it's been a while since you've sat down and looked at those rules, I would strongly encourage everybody to do it. I can say that, we oftentimes look at these rules in terms of an attorney's practice in my office when we get notification of an overdraft. And so all of the banks are required, if there's an overdraft or on an attorney's trust account, to send notification to our office, and then we will then send out a letter and ask for an explanation of the overdraft, and we will ask for several months going back of bank records. And that's a standard letter that will ask for all records that include the receipt, maintenance, and disbursement of funds in your attorney trust account. And so what that would include, and bank statements as well. So it would include your bank statements from your trust account, and then it would include copies of all checks that were deposited into your trust account, copies of all canceled checks that were written out of your trust account, as well as your client ledgers, which are required under the rule that for each client matter that you're handling, that there's an ongoing accounting of the funds that have come in to your trust account or gone out of your trust account for any particular client. And so the rule requires the creation and the maintenance of those records, and that attorneys perform monthly reconciliations with those records. And what ideally you want to be doing with your trust account records is you should be able to look at your bank statements and look at the balance in your bank statement, say at the end of a month, or really on any given day, but if you take it at the end of 1 month, and look at the balance. And then you should be able to go to all of your individual client ledgers, and as of the end of the month, tally what you should be holding in escrow and make sure that those two amounts match. And so that's really the way you reconcile your account each month. And it's a check to make sure that your individual record keeping for each client is correct. And then it coincides with your bank statements, or it's the same as your bank's balance. I can tell you that, oftentimes, obviously, all people make mistakes, and you can have a error in how you write an amount down. You can do math wrong. All of these things, human error, that may result in an overdraft. It's fairly typically easy for our office to look at an explanation for an overdraft like that and determine that this was in fact an error. And those cases are not going to, are going to, in most cases, the explanation will be sufficient. On the other hand, it's very easy to tell most times if the appropriate record keeping is not being done either at all or certainly not on a regular basis. And so I've seen this a lot of times as well with attorneys that just don't, for whatever type of practice they're in, maybe don't have a lot of money that's coming in and out of trust. As say, like if you're a extremely busy personal injury attorney and you have cases that you're settling all the time and a lot of money is coming in and out. Attorneys that tend to have less money coming in and out of trust, I think sometimes there's more of a habit of keeping the records, but also in your mind, I've seen it many times where attorneys just think, well, I know what money's in there. I've got, Joe's settlement and I have the retainer that, Tom paid. And so, and those are the cases where, mistakes tend to get made. And then we'll see an overdraft, and then that will sort of lead to, it'll be apparent that there was record keeping was not where it needed to be. So important to do that. And as always, cash withdrawals are prohibited from trust, and should not have an ATM card for your trust account or anything like that. And the idea obviously being that you need to be able to go back and track what was withdrawn from your trust account at any given time. So those are the rules. Those are the money rules. So now we've covered competence, diligence, communication. We've talked about fees and trust accounts. And sort of the next category of common areas for bar complaints is the idea of, honesty, misrepresentation. And the two rules that really encompass that are 3.3, which is the candor towards the tribunal, and then 19.308.4, and it's subsection C of that rule, which prohibits an attorney from engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. And these are the rules. Well, I shouldn't say that, because obviously if you're, the trust account issues and if there's theft or misappropriation, obviously result in, typically would result in serious sanctions. But as well, this is sort of the other category where there will be, typically if an attorney engages in this conduct, significant sanctions. So Steve will hit these. These are very deep thoughts about the don'ts on these rules.
Yes, I had to do a lot of homework and soul searching for this part. But yeah, Aaron's point is, don't lie to anyone. These issues, and we'll talk about mistakes that can arise and different ways to deal with them. You will not hear anything in this presentation recommending that you should lie about them or deceive anybody. Doing so, as you know, will only compound the issue and make things far, far worse. Particularly with those rules that Aaron just shared with you. What could be a relatively minor situation that can be dealt with or avoided can be grossly compounded and implicate additional ethical violations, if you try to cover things up or misrepresent things to the court, your clients, bar counsel, etc.
And even with this, the focus of this obviously being bar complaints as well, as Steve, will tell you, in the legal malpractice setting, oftentimes, if a mistake is made, it can be corrected. And I know he's going to talk about that later, but getting out in front of it and being upfront and telling your client what has happened and being as forthcoming as possible can actually then lend itself to potentially, if there's been a problem, fixing the problem down the road. But what goes along with that we see a lot of, and I'm sure anybody who reads any of the opinions coming out of the Court of Appeals on the disciplinary cases has seen that one of the things, and it amazes me sometimes, because when we have cases that are in public charges and before the Court of Appeals, you really, in some of these instances, you look at what the underlying conduct was. And the truth of the matter is, it's not that, it wasn't that egregious, or it wasn't that serious of a case to begin with. But the problem is then it's the cover up that happens afterwards, that then sort of just, it's a ripple effect, and then you're into a much more serious situation than it really needed to be in the first case. And so the rules that come up in those cases are, again, obviously 8.4C, because if the attorney makes a mistake or doesn't do something that they said they would do, and then tries to cover it up down the road, that implicates this rule. And actually, I just realized I have the wrong. It's 308.1A is this rule. I have B, but that's incorrect. So I apologize. But then, to make a knowingly false statement of material fact to bar counsel in a disciplinary investigation, that's, so then when, an attorney, maybe at first it's just, a small sort of not being fully forthcoming with the client. And then you get to the investigation of the disciplinary complaint, and that sort of continues. And then you're in the realm of these very serious rule violations, when at the outset, the case really might have been you made a mistake, but it's more of a legal malpractice case than a disciplinary case. Or it is just something that wouldn't have been as egregious until the cover-up begins. And then the other, area of that we obviously see a large number of complaints deal with Rule 8.4. It's conduct that implicates Rule 8.4, which is the general misconduct rule. And what I think is interesting to point out about this rule is that, the kind of the looking at private conduct and how that can be implicated in a disciplinary matter, because oftentimes, you have instances where the defense of a lawyer will be, well, I wasn't practicing law, or I wasn't representing a client, and therefore none of these rules are implicated. And 8.4,
Aaron, I think you hit your mute button.
Sorry. I don't know how much you lost, but
only a few seconds.
Okay, thanks. So when it's looking at private conduct and when can an attorney be responsible, and there are cases, if you look at some of the older cases in particular, that will say in terms of conduct that may have fallen under Rule 8.4D, which is sort of the catch-all, conduct prejudicial to the administration of justice. The court has made distinctions at times about private conduct, if it's not if it doesn't involve necessarily the practice of law, that may not fall under this rule. On the opposite side of that, there's 8.4B, which reflects criminal conduct. Obviously does not have any limitation as to the practice of law, whether you're practicing law or not. And one of the things that oftentimes comes up under that rule is tax issues with attorneys that fail to pay taxes. And so this rule is sort of one that we look at from both if you're representing a client and before the court, but also it does implicate private conduct under certainly under 8.4B. But if you do find yourself in that unfortunate situation, Steve is going to assist in telling you how to do this. So now my thing won't, I don't know what I did to this. Let me see. Oh, there we go. Sorry about that.
So before jumping in with kind of a stepping stone approach to addressing these issues, these 2 pointers are thrown in here as kind of the framework to operate from. and this will kind of be a recurring theme we talk about, not just in dealing with the mistake when it first arises, but also in responding to bar counsel. But, the first step here is to not panic. Let's sit and try to be as objective as possible, looking at the facts, and just the facts. Don't jump to conclusions. As we'll talk about, there are some issues that even when they arise and they seem like they might be a major problem, they may not actually be as bad as they first feel. Erin, can you go to the next slide for me?
Sure.
So first thing that we recommend is that go to your carrier. And the reason why we suggest this is multifaceted. The first one being that if you have a claims made policy, you certainly want to err on the side of getting your carrier involved sooner rather than later and make sure that they are on notice of a potential claim. But the other reason too is that the sooner you do that, you may have coverage for pre-claim assistance, or you could get counsel involved to advise you and walk you through the appropriate steps to take in trying to mitigate a problem. As you can imagine, when you have your insurance company sitting there looking at dollars and cents of what's it going to cost me to litigate a legal malpractice, underlying medical malpractice case from beginning to end, versus I could get counsel involved, pay them a little bit early on to help them avoid this problem altogether. It's a very intelligent approach to trying to mitigate a problem before it expands into something much larger. Part of that first step, once you get counsel involved or not, is to addressing the problem with the client. And this is certainly the hardest part of having to face the facts and deal with this issue with the client. But when you do that, again, do not jump to conclusions on your own and sit there and say, oh, clearly I have malpractice, or this is negligence. Oftentimes, and in certain situations, what seems like you have clearly dropped the ball may at the end of the day not have impacted the outcome of the case. So as we'll talk about between this slide and the next one, what you want to make sure you do is go through the factual situation with the client so that they understand what the issue is and how we got there. But you sitting there and connecting the dots between A and C, which may not exist, is not going to benefit anyone at the end of the day, and may open you up to a problem that you do not necessarily need to expose yourself to. Because as you can imagine, 99 times out of 100, if you sit there and say to the client, yeah, I malpractice here, I cost you your case, that will be used against you at some point in time. So, what do you do with that client in dealing with this problem? As laid out on the slide, when you're bringing them up to speed, you must advise them to contact independent counsel. If you have made a mistake in the course of the representation, then obviously you have a conflict because you yourself have an exposure that's at odds with the client's representation in that case. So what I advise people to do in this situation is, when you are bringing the client up to speed and advising them to contact independent counsel, sit down with this information set forth in writing, go over it with the client, and then provide them with that advice in writing so that there's no confusion about when you met, what you went over, and that it's memorialized in a document that you can refer to later on. Not only doing that will protect you at least to a degree later on with making sure you complied with your ethical requirements, but as noted on the slide, it'll also start the statute of limitations running, since legal malpractice claims, just like any professional malpractice claims in Maryland, follow the discovery rule, and you telling the individual client that this was a mistake that was made and here's what happened, certainly puts them on notice. So those are the ways that, in first addressing a mistake, especially if you are being guided by counsel, getting an extra set of eyes on the letter and going over how to address this during the meeting, are effective ways to try to get out in front, as Erin described, and try to, fan or not fan the flames on one of these claims, and try to mitigate it as much as possible.
I think also one of the things that I see quite frequently is if a client is dissatisfied with their attorney, and typically it will happen at the end of the representation, not all the time though, and they're trying to get in touch with the attorney because they want an explanation, or they're frustrated about the fee and want an explanation, and don't get one. And then, so they file a complaint, and then we'll send the complaint to the attorney. And, the next thing will be if the attorney may respond, and then we may send it back to the complainant for comment. And then the comment back at that point will be something to the effect of, oh, well, this attorney is great. I withdraw my complaint. No complaints here. And oftentimes, not oftentimes, I shouldn't say, but what has happened is then once the attorney gets the complaint, then they contact the client to say, whoa, what did let's work this out. And oftentimes what can happen with that, again, is the attorney then attempting to settle the case with the client in exchange for a release potentially of a legal malpractice claim, but also for agreeing to, and I've seen all sorts of language, for agreeing to withdraw their complaint with bar counsel, for agreeing to not cooperate with bar counsel in their investigation, agreeing things like that the attorney then puts into a release with the client. And I'll let Steve talk about all the practical problems that creates, but from the perspective of bar counsel, one, it's not the client. Once the client files it, it's not their complaint to withdraw. So the attorneys oftentimes, it can be shooting yourself in the foot because, the complaint will still be investigated. But also you probably are going to run into more difficulties then because of the concerns that Steve has already talked about and can talk about in terms of trying to settle those claims without without giving the proper disclosures, and also the conflict that's created by attempting to settle a bar complaint.
Right, absolutely. That's one of the things when I say to keep a comprehensive written retainer agreement. That's another issue, that you can't have that in there of you can't agree to not turn me into bar counsel when I act unethically. So certainly you want to keep those issues in mind when we'll talk about here in a second, dealing with a bar complaint when you receive it, because there's a way to go about dealing with those issues and responding to bar counsel. And as Erin alluded to, the way to do that is not to try to broker a under the table deal with the complainant and then try to secure a release for yourself, because you walking into a conference room with Erin and waving a piece of paper and saying, you can't take my examination under oath, I have a settlement agreement with the complainant. I don't think that's going to achieve the result that you're hoping for. Okay, so responding to bar counsel, if you find yourself in that situation where you do receive the dreaded letter in the mail from bar counsel, similar to identifying when a mistake is made. First step, you should check your malpractice insurance, contact your broker, turn in the claim, see if you have coverage. Policies do provide defense costs to be covered, usually subject to a certain limit, without a deductible. And the reason is the same as we talked about before, where from the insurance carrier's perspective, if you can get counsel involved early that handles these complaints on a regular basis and can address it on your behalf and hopefully avoid a snowball effect with, not just a bar complaint, but also a potential future legal malpractice claim, then that's in everyone's best interest. I put in here, maybe this is my own personal view, that bar counsel prefers to deal with counsel rather than the respondent, and I won't ask Erin to comment on that. But typically when people know and are familiar with the process and responding to bar counsel in both addressing a complaint but also going through the investigative process, then counsel is usually there advising a respondent that these are the do's and don'ts. And while you may feel like this is the most egregious, unfounded complaint lodged against you, there's a tactful way to address that and respond to bar counsel so that they can do their job, cross their T's and dot their I's, and hopefully at the same time for you are putting your best foot forward and demonstrating a pattern and practice in front of bar counsel that you aren't this monster that the complainant has portrayed you as in their complaint. And it's been certainly my opinion that the results under that scenario are far likely to result in a positive outcome than when people try to go this alone, especially the first time, and trying to figure out what tone to take in their initial response, how aggressive to be, how much to talk about, how little to talk about. These are all issues that experienced counsel can assist with in trying to prevent what could be a small issue from snowballing into a much larger issue. Okay, so if you do not have insurance or you choose to go this route your own, what are some tips to addressing this? The first thing that typically advise people to do is just take a minute. Don't rush into things. Don't start and fire off a missile in response to bar counsel. Addressing every single point in this letter. Give it a day. Digest it, think about it, reflect on it. Secure the documents, the file, but don't dive right in. As you see there, the previous note here is that the time limits in business days, it's actually nowadays it's set forth as a specific deadline you'll have to respond. And you'll see that you have time, it's not an imminent deadline to file a response. Certainly do not bury your head in the sand and think that, if I close my eyes, bar counsel can't see me. That is not how this process works. You want to make sure that you are complying with deadlines, you're cooperating and responding to counsel appropriately. So after you've taken time, you've waited a day, the phraseology we like to use is drafting, your lawyer-like response. And you want to start thinking about how is the most effective way for me to address this complaint and hopefully knock it out at the outset. So when we talk about the first tip here in responding with dealing with the issue, first of all, just because someone has complained does not mean that it is an ethical violation in nature or warrants discipline. There's, as you saw, there are thousands of complaints that are filed. The data that Aaron shared talks about, 1,600 complaints are received, and you saw that a huge percentage of those are dismissed at the very initial stages. I think based on the data she had, 1,300 of the 1,600 are dismissed. So you want to do everything in your power to be within that 1,300 class that is able to get out of this without having to go through a docketed investigation through bar counsel's office. So when we talk about dealing with the issue, again, if the person's completely off the rails, you still you want to be candid, you want to be short, succinct, to the point, address the issue at hand. Don't feel the need to talk about, since I was in kindergarten, here's everything that happened in my life. Because keep in mind too that bar counsel, they are not limited to the issues that are identified in the initial complaint. If you decide to go off on a rant and identify, every issue you can think of under the sun, you may say something, innocuously and not think anything of it, but it might raise, a flag in Erin's mind where she says, you know what, you're right, that's something else I might want to look into. So you want to be direct and address the specific issue at hand. But again, you need to completely answer the question. You need to specifically answer what's being requested, not venture off into left field, not avoid the question. It's not going to go away if you try to, play word games and avoid addressing, the elephant in the room. And then you see on the bottom there, be on time. Do not make, bar council have to follow up with you. Don't ignore deadlines. That certainly is not putting your best foot forward and not showing that you are trying to be one of the 1,300 to try to get out of this early on.
And just to chime in on the, going back to the number of complaints that we receive versus the number that are docketed, the rules are limited in terms of declining a complaint. So typically, if a complaint is received, it is being sent to you as the attorney for a response in the initial screening phase of the complaint. And that's the first number that you saw of how many complaints we receive. They're being forwarded to the attorney for a response. The docketed number, the 285, and it dawned on me that people might not necessarily know, nor do you want to, I'm sure, all the ins and outs, but really the importance of that initial letter and attempting to resolve or dispose of the complaint at that point is also the practical side of it, which is once at the screening stage, that initial level before a complaint is docketed, the ability to close a file or dismiss a complaint is completely within Bar Counsel's purview. Bar Counsel has that ability. Once the complaint is docketed for investigation, there will be an investigation of the complaint and the allegations. And then at that point, it may still be determined that the case should be dismissed, that whatever gave concern to cause it to be docketed, in the investigation is realized that that's not a problem. But at that point, then Bar Counsel cannot just dismiss the case. The case then, there has to be a recommendation to the Attorney Grievance Commission, and the Attorney Grievance Commission then has the authority to dismiss the case. So, that really, I think, puts into perspective, one, the numbers that you see between how many complaints we get versus how many are docketed, but then also just the importance of trying to deal with the case and move on in that first letter.
So part of those steps in putting together a response, these it sounds self-explanatory and commonsensical, but you'd be surprised. These are things not to do with your initial response. No matter how tempted you may be, including insulting Bar Counsel's office, you will feel the need that some of these complaints are a personal attack. Do not reciprocate by insulting, the complainant. Certainly not anyone in Bar Counsel's office for sending you the letter. Or anyone for that matter, because as you can imagine, that's not going to be well received to show that you're able to take a step back, be objective, and be able to respond accordingly. If anything, you're just going to be throwing gas on a fire. Even though, especially with litigators, your initial gut reaction is to fight. There's a time and a place for it, and there's an appropriate tack to take. And this is not the stage to take that tone or that level of hostility in your written response, in response to the complaint. As we talked about before, don't avoid the issue. You need to address it head on. The more direct and appropriately you address the issue, the greater the chances is that you can, figure out early on what direction this is heading and whether or not this can be dismissed at the initial screening stage or not. And the best way to do that is to, don't hide the ball. Address the issue, be matter of fact and direct, and then, you can proceed from there. Final tip on there is, also you talking about how great you are as a lawyer, as a human being, all of those factors. While those all may be wonderful, true things, they are not going to detract, bar counsel's attention from what is the issue is. So in finalizing your response to bar counsel, in which, assuming you have not insulted anyone or attacked anyone and followed the initial steps of being direct and concise and timely, always recommend showing it to a colleague whose judgment you respect and someone that you would trust, to tell it to you straight too. You want someone that will be level-headed, but also can review this and would not be afraid to tell you, I think that you're missing the forest for the trees here, or that really doesn't answer the question that's being asked of you. I find that having a second set of eyes on anything, particularly of this level of importance, is very helpful to make sure that you are putting your best foot forward. Same thing at the end there about proofreading your response. These all sound like basic things, but you'd be amazed. I'm sure Aaron has seen instances where people have not instilled a lot of confidence in some of the work product that they've submitted to bar counsel when it's a license issue on the line. And my mindset would certainly be that if I'm being called to the carpet, my response is me saying this is my best foot forward. And if you have a bunch of grammatical errors, spelling mistakes, and things of that nature, it certainly doesn't send the message that I would think that you want to send to bar counsel, who ultimately is going to be dealing with this issue and investigating your fate going forward. Okay.
Yeah, we wanted to give you guys a little preview of what may be to come. The 207th report of the Rules Committee has been presented to the court, and this includes a complete kind of revising of the rules in disciplinary matters. There's a number of proposed changes to those rules, and it's available. We put the link up there, and I believe they're in the comment period now, I believe. And Steve was just going to give a couple little taste of some of the stuff that may be coming down the road.
Yes, so it's a huge document. There's a number of rule proposals. It is in the comment stage. I think that this was pushed along earlier this month. So we'll talk about in a minute that there is an open meeting scheduled virtually in the Court of Appeals, but tying into some of the issues we've talked about here today, Aaron talked about what happens once a complaint is docketed and then it can only be dismissed through recommendation to the Attorney Grievance Commission. Some of the rule proposals that are included within that document, which again, it's a huge document, but if you search for the 19- rules, and you'll see them outlined or indexed at the beginning, you'll see some of the potential professional responsibility issues, some of which we've talked about. Some of the ones we wanted to highlight for today was really a modification that's being proposed to change what I'll call a lower level sanction, although it's not considered actual discipline, of being issued a dismissal with a warning would basically be split into two prongs, one being a dismissal accompanied by a letter of cautionary advice, or a dismissal accompanied by admonition. So what we see is that if these sound familiar to you, it's because they are falling more in line with the Judicial Disabilities Commission rules. And my view of this, at least, was that this is a matter to somewhat bring those more consistency between some of the nomenclature that's used.
And so what you'll see with the and as it stands right now, if the recommendation is made to the Attorney Grievance Commission to dismiss a case with a warning, some of you may know just from reading the rule, not from experience, that what happens then, the Attorney Grievance Commission will send a letter saying that they want to issue or intend to issue a warning to the attorney for the conduct, and the language of the warning will be included in that letter so the attorney knows what would be issued. The attorney then has 30 days to accept or reject the warning. And the warning, as Steve said, does not constitute discipline, and it can only come up in a later proceeding if it's for the exact same conduct. It can be potentially used in a later proceeding. So what's happening with the new proposed rule is sort of, as Steve said, to split that. And so what you would have is still neither the letter of admonition or admonition and letter of cautionary advice. Neither is going to constitute discipline, but it's going to be that the admonition, the attorney would still have the ability to reject it and then go forward in the disciplinary process, whereas the letter of cautionary advice would just be issued. And so one of the issues there that I know came up, my understanding is in the Rules Committee about that, is also who gets notification, because oftentimes with the warning, the complainant will be notified that a warning was issued at the end of the case, but the complainant does not receive the actual language of the warning. And so this sort of deals with that issue as well, where the complainant with the admonition would see that there was an admonition issued, and with the letter of cautionary advice, they would not. So it's just another sort of, it's essentially splitting what the current dismissal with a warning is into two. And that was really the main one I think that we were going to touch on. There are some other, interesting just changes to the process. And so I would encourage everybody, if you have any interest, to take a look. And then here is the information for the meeting. And I think we did pretty good. Our goal was to leave about a couple minutes 10 minutes for questions. And I think we're right about there.
Yeah, we have questions, Erin, and we have a question in the chat, actually. The question, if I can pose it to you guys, is any thoughts on your use of the peer review? Can you touch on that?
Any thoughts on the use of the peer review?
Yeah, use of peer review.
Sure. So for those of you that don't know, at the end of an investigation, this is once a complaint is docketed and there is an investigation. One of the things, the next step in the process is if it appears that, or there's reason to believe that misconduct did occur, the matter can be referred to a peer review. And that's where essentially there's it's intended to be a group of an attorney's peers, anywhere usually from 3 to 5 attorneys and then one public member that meet. There's a statement of charges is prepared by bar counsel and submitted to the peer review committee and to the attorney. The attorney has an opportunity to submit a response, and everybody, you show up. Normally you would be in a conference room. This past year, it's been mostly all virtual. And it's really an opportunity for bar counsel to state the case, the attorney to respond, and then have a group of the attorney's peers weigh in on it. And at the conclusion, they make a recommendation to the Attorney Grievance Commission. And I won't get into the nitty-gritty details, but those recommendations can either be agreed upon by everybody or not agreed upon, depending on the circumstances. And I think peer review is a really great and effective way to, it's a great and effective part of the process, I think, because it really is an opportunity to hear from other attorneys, often who practice in the area that the misconduct took place in, who can offer a different perspective, and sort of give an analysis of the case at that point. And I think it works both ways. At times it can show, bar counsel what may have been not apparent before in the investigation, or it can also help the attorney to understand where they might not feel that there's been any misconduct, that if a group of his peers or her peers, says this is problematic, it can help facilitate a resolution of the case that might not otherwise be able to occur. So I think it can be really effective. And certainly the attorneys that serve on the peer review committee were very grateful for if any of you do, because it can be a time commitment, but we appreciate it.
We had another question here too. It says, can the notification from Bar Council also be sent to the attorney by email, but in addition to the post office, sending it by regular mail? If an attorney is off on travel, at least that attorney can get the notice by email while outside of the office. Is that typical that you send it email and mail, or is it just usually snail mail?
Typically, we had always just done snail mail, but with COVID, we have started to do much more communication by email, which has proven so far to be pretty effective. And so oftentimes now email would be the first way that a letter would go out. And then, if there was no response or something gets a bounce back, then we would use snail mail. I would say also to make sure, because obviously the information that we have is what you have on file with the Client Protection Fund for your email address and your most recent contact information. Under the rules, that has to be current. So make sure, I think it's a lot easier now with AIS to go on and update information, but make sure that your information is correct, because that's what we have to use, and that's what we have available. So
I don't see any other questions in the chat unless anybody wants to chime in. While you're doing that, while you have that last minute, I did want to put in a plug for Ralph Sapia here. Ralph is the vice chair of the committee. He's going to be writing the article on this for the Advocate. He'd love to hear from anybody who attended what you've learned from this seminar. I already told him what I thought I learned, which is the fact that I was thinking about suing a client, and now I am thinking maybe I shouldn't do it after hearing from you guys. I hadn't decided what I was going to do yet. I hadn't done it before. And now I'm definitely pausing on it before thinking about suing. So that's what I've learned. So I hope you guys all got something out of this. Thank you again, Aaron and Steve, for your time and the information. And thank you to Rachel also for running this. And I appreciate, you being available a year later to do it. So
thank you.
Thank you. We appreciate it.
Okay, well, everybody, that's it for us tonight. So take care. I hope everybody has a good evening.
Bye.
Bye. Thanks again.